Well, good afternoon, everybody. Welcome to the Samfiru Tumarkin live employment law show on Facebook and YouTube. My name is Chen. I'm an employment lawyer at our firm's Vancouver office. I'll be here for the next half an hour or so live, answering any and all questions to do with employment law. So if you're having issues with your boss at work, a colleague at work, if you just got a new employment contract, if your company's being sold, or if you're being let go, unfortunately, please feel free to ask any and all questions to do with employment law. I do have some topics that I do want to talk about today for our regular viewers, but I will put priority to the questions. So even if I'm talking about something else, please feel free to cut me off. I can't see anybody, but hopefully everybody can see and hear me. I'll be able to see your questions on the text box in front of me. So please feel free to just jump in and we'll get started. I see we got a comment here from Keisha. Hello. So the topic I wanted to talk about today is it's a bit of a difficult topic. It's about terminations. And the reason I talk about it is because, from my perspective, a lot of people come to me when they've been let go from their job. It's probably, hopefully you don't have to go through it, but most people do at some point in their life go through with termination, whether it's their fault or not, right? Some people are just laid off. Some people have been let go because they did something wrong at work. So I wanted to touch on that topic and what to do if you've been let go. So typically, there's no, formal legal, way you terminate someone, right? They can do it over email, they can do it with a phone call, or they can have an in-person meeting, right? There's no set way to do it. Usually someone from HR will bring you into a meeting, and they'll tell you that you've been let go. And during that meeting, they might give you some paperwork, okay? And that paperwork will probably be your termination letter, and it'll say you're being let go. It might give you a reason that you've been let go. In Canada, if you're non-unionized, they don't have to give you a reason. Okay, they can just say we're letting you go, and on a without cause basis. They don't have to give you a reason. So that piece of paper, your termination letter, will have some important details. During that meeting, your boss or HR. We got a question here. So we got our first question here today from Farah. So guys, like I said, I'll put prior to the question, so please feel free to just jump in, even if I'm talking about a completely different topic. So we got a question here from Farah. What options do you have if you feel like the owner of your company is trying to force you out? I'm in my 60s, and it seems like my boss expects me to retire soon. Bro, that's a really good question. There's a few different issues in that scenario you just described. So if someone at the company, your boss or whoever, is trying to force you out, there's always a question of whether it's called a constructive dismissal, right? It's essentially, the legal term is constructive dismissal, but essentially means that they're firing you without saying they fired you, right? So if they're just, if they're giving you a really hard time at work, if they're making up, performance issues, if they're bullying and harassing you, if they're just, making offhanded comments to you, anything like that, if you feel like they're trying to force you out, that could be a constructive dismissal, right? Nobody in Canada has to work in a toxic work environment. So if you feel like someone's trying to push you out and they're taking, actions to do that, the biggest issue in those cases is evidence, right? What evidence do you have to prove that the owner is trying to force you out? So that's one option, right? If you have the evidence to back up the fact that the company is trying to force you out, you could claim a constructive dismissal, right? Because they're basically trying to get away with not paying severance pay. And so that's one option. What you should do, for us, you should probably start keeping a notebook of everything that happens at work, right? So today, September 15, 2022, at time X, 1:02 p.m., my boss said this, or my boss did this to me, right? Just some sort of contemporaneous record that you could use to try and prove that they're trying to push you out. What that would do is that would serve as evidence of a constructive dismissal case. You're trying to prove that the company's acting dishonestly. The legal term is in bad faith. The second part of your question, Faral, goes to it raises this issue of discrimination, right? Very, very few occupations have mandatory retirement ages. Very few. Okay, you're probably in an occupation where if you're in your 60s, you might want to work until your 70s or whenever, right? If the reason the company is trying to force you out is because of your advanced age, because you're in your 60s, right? That's contrary to the BC Human Rights Code and the Human Rights Code for other provinces in Canada as well, depending on which province you're in. You can't let someone go or try to push someone out because of their age, right? And if you force someone to retire, that's also discriminatory. So just keep that in mind. It sounds like, if they're trying to push you out because of your age, you have two potential paths to go, right? You could claim constructive dismissal and claim for severance pay, or you could try to claim discrimination on the basis of your age through the Human Rights Code or human rights legislation in your province. So all of this obviously needs evidence, right? You need to whether it's in writing or maybe your boss or somebody at the company said something to you like, hey, Faral, why aren't you retiring? That's all going to come out obviously if you decide to pursue this. But my advice to you is, because it sounds like quite a complex situation. There's a lot of factors that I don't know about that you probably can't share with me on here. You should talk to a lawyer before you make any major decisions. If you're in BC, come talk to me. My contact information, if you go to employmentlawyer.ca, you should find my contact information. I'm happy to chat. But I would say that because there's so many issues at play in your case, Farad, that before you decide to do anything, probably get some legal advice. Okay. So if there's any follow-up questions for our or anybody on here, please, you can just type your follow-up questions and I'll get to it as soon as I can. So we've got more questions. All right, we got a question from Jay. If you work on call for a company who ends up losing the contracts that you generally work under, and that company doesn't inform you, is there a point where severance is triggered? I heard that another company picked up the contract. Yeah, Jay, I think it's generally, I'll say yes, you're still entitled to severance, okay? If a business loses a contract, if a business goes bankrupt, if the economy is bad, if sales are down, that's usually not a reason for any employer in Canada to avoid severance pay. Now, if the employer is bankrupt, that's a whole separate issue. But if it's just due to, a slowdown in business or losing a contract, generally it's severance pay is still going to be payable. The second issue in your case is how much severance. Your written employment contract will obviously dictate how much severance pay you get. Whether it's triggered or not, I've seen employees with a day or two of service that still get a substantial amount of severance pay. If you're on call, if you're not guaranteed hours, that's another issue there, Jay. I would say if you've been with the company a while on call, you're still entitled. It really depends on the terms of your employment contract. But as a general rule, I'll say that losing a contract or a slowdown in business is not something that an employer can use as a reason to avoid paying you severance. So we got another question here from Giovanni. He asks, can an employer refuse someone who is suicidal even if he has not attempted suicide? So Jeremy, that's So I guess, what do you mean by suicidal? I mean, sorry, what do you mean by refuse? Um, refuse to do what? If you're talking about to hire that person, then that could be an issue under the Human Rights Code. So let me explain. So if you're, I don't want to make any assumptions, but if you're, suicidal, you might be suffering from some mental health conditions, right? Maybe, I don't know. A mental health condition is a protected ground under the Human Rights Code in BC. And so if an employer is refusing that person to hire or to give him a raise, give him or her a raise or anything, right? If you're refusing a benefit to an employee just because that person is suicidal, that's, I'm going to say likely, or it could be, discrimination under the Human Rights Code, because that person could be suffering from, some sort of mental illness that's causing them to be suicidal. So, if you want to clarify your question, what's the employer refusing to do? And if that's, even if he has not attempted to suicide, I don't know that the fact of whether he's attempted or not attempted suicide really matters in the analysis. But if you can clarify your questions a bit more, I'm happy to try to follow up on that. So Jay, your follow-up, you're saying you've been on call since 2009, no guarantee of hours. Again, Jay, that's a long time to work on call. You could imply a term where your set hours of work are whatever, 10 to 20 hours a week, right? I'd like to see your employment contract, Jay, because if you've just been hired and the contract says no guarantee in hours, you're on call, that's a different situation than someone who's been working that role for 13 years, it sounds like, and you've been consistently and if you've been consistently working every single week, right? And what the explicit terms of your contract also says, I think also matters too. But just by sheer virtue of your length of service, I'd like to see the history of your hours and what your contract says. But just if whatever province you're in, if you're in BC, you can come talk to me. If you're in Ontario, I have colleagues in Ontario or Alberta. But just because the company lost the contract doesn't mean you're not entitled to severance pay. And if they're refusing it, they're gonna have to explain their rationale. Okay, so I think that's, hopefully I haven't missed any questions there. For anybody that's joining us now, please feel free to jump in with your questions. Like I said, I'm gonna put priority to those, to the questions. Okay, oh, we got a new one here. We got a question from Paul. New supervisor on your work site says you are no longer owed overtime pay. Is this because I work in construction? Paul, it's a good question. So, I'll start by saying that each province has their own overtime rules, right? If you're a provincial employee, if you're provincially governed, most people are. So in BC, just because you work in construction doesn't mean you don't get overtime. There's special exemptions for overtime. There's special exemptions for construction employees in BC. One of them being, if you're let go, you might not get statutory termination pay. You could still be entitled to severance, but there's certain exemptions for construction employees under the Employment Standards Act, and one of them is termination pay. Overtime in BC, I don't know why they're saying you're not owed overtime just because you're a construction employee. I'd ask them for the reason, Paul. Most employees in BC, if you're not a manager, right, you should be getting overtime pay. And Paul, the second part of it is, with construction employees, there's actually a legal test as to whether you're construction employees. More often than not, it's not as clear as people think. So Paul, I would ask them to clarify why you're no longer entitled to overtime. If they say it's because you're in construction, that's not a reason. Okay, so we've got a question from Jay. Oh, a follow-up, sorry. So Jay, you're saying your hours fluctuate, 30 to 100 hours per month, I would say, and yes, in BC. They're not even notified me that they lost the contract. However, I know what company now has it. Yeah, Jay, I think you gotta, I mean, look at your contract. If they do let you go, Jay, come talk to me about it. If you've been consistently getting 30 to 100 hours a month for 13 years, I mean, I'd say there's a good chance they owe you severance if they decide to terminate you, right? It sounds like right now they haven't even terminated you and you're still getting hours. So, I don't know if you have a written one that you can find from 13 years ago. But if they do decide to let you go, that's going to be the first piece of paper that we look at. Okay, guys. So I think those are the questions. Like I said, if anybody has any follow-ups, please feel free to type the question in there. So I think I was talking about termination meetings before. So everybody, so let's go back to the termination meeting. You're going to have a meeting with HR. The number one piece of advice I would give people is, and I'm sure most people know, don't sign that paper they give you right away, right? Even if you're under pressure. At your meeting, whether it's a phone call or in person or a Zoom meeting or whatever, most of the times, almost always, you'll get a termination letter after. And a lot of times it'll say, hey, if you sign this release, this document, we'll give you an extra week of pay or 2 weeks of pay or something like that. That's you should take some time and think about that and do some research on that offer before you sign that document. And the reason why is, and by research I mean either talk to a lawyer be the best way, I would say. Our firm has a tool called Severance Pay Calculator. It's a rough guideline. If you go on it, it's actually sometimes pretty accurate. But if you go on it, you can kind of type in your age, your length of service, and your position, and it'll kind of pop out a number of how much severance you could be entitled to, right? So for example, if you've been with a company 20 years, you're a manager, and you're making $100,000 a year, and you're let go, and the company offers you, let's say 2 weeks pay to sign their release, which the release just means you can't sue them, right? That's what that means. Yes, hello, Ice. Yeah, you can ask questions via YouTube for sure. You just have to type in the text box because I can't see or hear anybody. So while we wait for Ice's question to come in, let me just finish my point. So if you've been with a company a long time and you're fairly senior and you've been let go and they offer you 2 weeks, that's probably not going to be enough, right? If you go to our firm's website, so employmentlawyer.ca, there is a severance pay calculator, which will give you a rough guideline, right? It'll give you a range of notice periods you could be entitled to. Sorry, by notice period, I mean a range of severance pay that you could be entitled to. So if this person that in my example had gone to that and plugged in, their age, their position, their length of service, they probably see that they're entitled to as much as 18 to 24 months pay, right? And so that's kind of the difference people are looking at. So that's number one. You should do your research before you sign that document, which I know a lot of people do, but it is very, very important because I've had people come to me who have signed the release, and most of the time I tell them I can't, it's hard for me to help them after you've signed that piece of paper. It's still possible, but it makes the case a lot harder if you've already signed by the time you've come to me to talk about it. So that's number one. Number two, I would say, a question I get a lot is, should I try to fight the termination at the meeting? Should I, try to push back and explain why their reasoning isn't right? I mean, obviously, look, you never say never, but I haven't heard of a case where that's done anything, right? The company's made a decision. The person delivering a message usually doesn't have the authority to kind of overturn that decision to let you go. there's not really too much of a purpose in trying to fight back and start yelling and all that stuff. But it's important to listen, right? It's important to listen, especially if they give you reasons for termination, right? A lot of companies don't because they're not legally obligated to. But if someone in the meeting says, "Hey, here's why you've been let go," and you should listen carefully. And my advice is right after that meeting, note down everything that happened in that meeting, everything that was said to the best of your memory. Note down what they said was the reason for your termination. Okay, that's important because especially if you're in a case where you feel like you're being discriminated against, or if you feel like you're being retaliated against. The reason they give you is important because that's their position, right? And afterwards, you have to try to prove that reason didn't make sense. So if they say we've eliminated your position, and it turns out that the company has not eliminated your position, that's going to help in if you have a discrimination case or a retaliation case, right? If you can disprove the company's reasons. So I think that those are probably my top two pieces of advice. Don't sign the paperwork, look it over. Sometimes, even if there's pressure to say, look, I need a few days or I need a week to do my research, and try to listen and note down what's said at the meeting. I think, a lot of times, it's obviously a very upsetting thing to go through, but there's no point in really arguing during that meeting or during that phone call or Zoom call or whatever. The common question that I get, that I know, because I know some people have probably been Googling severance and all this stuff. Another common question I get is about this looking for a new job after you've been let go. And there's a lot of I don't want to say a lot, but there is some misinformation out there, right? And the misinformation is that severance is just this cash payment you're entitled to. It's unfortunate that it's not, right? There are certain, and I don't want to say, there are certain statutes. I know one particular in Ontario that you actually are entitled to, under the Employment Standards Act, severance pay, right, which is cash. In the vast majority of cases, severance is actually the company paying you in lieu of notice. And so with that, if you think about it this way, it could be working notice that the company gives you instead of any severance pay, right? So a company gave you 12 months working notice. And the purpose of the severance pay is to give you a buffer between jobs. Now, what our courts have said in the past is that, well, the state of the law as it is right now is if you're let go, you have a duty to mitigate. And all mitigate means is you have to make best efforts, reasonable efforts to find a comparable job, right? And so the surprising answer that I give to a lot of people is, if you've been let go and you're pursuing severance from the company, you have a duty to look for a comparable job. And if you don't, and it ends up in front of a judge, which most of these cases don't, but if it does, your severance pay may actually be reduced. And so hopefully that clarifies for some people. So sorry guys, I know we've got some questions here. All right, we got a question here from Rachel. Rachel asks, you were promised pay during the training course for your job. It's been 3 weeks and you've yet to be compensated. Is this legal? Yeah, Rachel, I think it depends on the province. I think in BC, it's monthly that they have to pay you. And I guess I can look at the act, but yeah, Rachel, it might not be illegal. I haven't looked at the act on this topic in a while, but I'm fairly certain. I think it's a month that they have to pay you. So in BC, at least after a month they haven't paid you, then yeah, it's technically illegal under the Employment Standards Act. But yes, you should be paid for that training course within a month. So we got a follow-up from Jay. If terminated, does the former employee have any rights to obtain the security footage or recordings of the termination, assuming that it was in a place that was under surveillance? Yeah, Jay, that's a really good question. It's so I have a few just a few points to keep in mind. You so first of all, through a lawsuit, right? If you sue the employer for wrongful dismissal, you can get that footage or recording through that proceeding, right? Because the company has an obligation to produce all relevant evidence to you, which would include that security footage or recording. The second way, and it is sometimes I know employees during meetings record that termination meeting, right? Surreptitiously. You don't tell the employer. So obviously, you can sometimes employees do it. It's not technically illegal, but that's another way to if you want to record the termination meeting, right? In terms of a right, an unfettered right to get the security footage, I would say without a lawsuit, I'm not aware of any legal paths to get there. If you're part of the recording and it goes into your employee file, it could be something that can be accessed by requesting a copy of your full employee file. And that can be done through the privacy commissioner. So all of that to say, Jay, there are multiple ways to get that. And I think the easiest way is probably through a lawsuit where they have to produce that. Okay, so I think that's all the questions we have. And we have a few minutes left, so if anybody else has any last minute questions, I'll wait around for a few minutes. But just to finish off on this topic of termination meetings and what you have to do afterwards, it's the duty to mitigate. It's kind of unfair in a way because, and most people are surprised to learn this, but if you find a new job a few weeks after you've been let go, your severance pay might be limited because you found that new job. It's almost a double-edged sword. If you find a new job, first of all, you're under a duty to find comparable employment. But if you do find comparable employment, that almost hurts your severance case because any money you earn in that new job is probably going to be deducted from your severance pay. And so I guess the message I'm trying to communicate is this issue of severance pay, it's not as straightforward, as 10 months, right? A month per year of service is something that's that people say. So it's not necessarily as simple as that. There's nuances there. It's a bit more complex. So I think if you've been let go, go to severance pay calculator. Go our severance pay calculator. Just keep in mind that that's an approximate range. It doesn't necessarily reflect your actual entitlements. And if you've been let go, you are under this what's called a duty to mitigate, which means you have to go out and make best efforts to find a new comparable job. And I would suggest documenting that job search in a spreadsheet or somewhere else where you can prove what you've been doing. Okay, so we got a last follow-up from JX2 here I'll take before we sign off for the day. So Jay, you're saying you meant there was around-the-clock video surveillance, not necessarily attached to a file. Yeah, Jay. I mean, look, listen. My answer stands. I think if we file a lawsuit for wrongful dismissal, and there is footage, audio or video of the termination meeting, I think that would be relevant, right? And then I think you have a right to access that information. And any confrontations, right? To the extent they're relevant to the lawsuit. If there's a meeting or a confrontation in the workplace that's relevant to the reason that we're suing them for wrongful dismissal, yes, that you could get that through the disclosure process in a civil lawsuit. Okay, guys. So I think that's all the time we have for today. my colleague Dan, I believe, is on tomorrow. So if I've missed anything, please come back tomorrow. I will be back in 2 weeks, same time, 1 p.m. On a Thursday in 2 weeks. But yeah, thanks everybody for tuning in, and I'll see everybody in 2 weeks.